Good afternoon, and welcome to Berenzweig Leonard's podcast on immigration, free speech, and the Supreme Court. I'm John Polk of Berenzweig Leonard. With me is my colleague, Kristin Zech. And we are going to talk about a very interesting Supreme Court case that's pending argument next week. This is a case involving immigration and criminal law, and it may have significant impact on the practice of immigration law by immigration lawyers and others. The name of this case is Senenyang Smith versus the United States. Now, this is a criminal case. In this case, what happened is the defendant was an immigration counselor, and she was advising clients on how they could become permanent legal residents. She told them that she could secure for them a labor certification, and the labor certification would allow them to remain in the United States pending completion of applications for permanent residence. She told this to hundreds of immigrants and charged them money. The problem was that she knew that none of these immigrants were eligible for the labor certification. She defrauded them, and at the end of the day, she defrauded them in the aggregate out of more than $3 million. So she was indicted and convicted of mail and wire fraud, but she was also indicted on another provision in the Immigration Code, which says that it is a felony for a person to encourage or induce an illegal alien to remain in the country. And she was convicted on that count as well. She took that issue on appeal to the Ninth Circuit, and her argument was that the statute was overly broad and unconstitutional, that the language encourage or induce is simply too broad, and it covers protected speech. In addition to unprotected speech, it covers a great deal of protected speech, so it's overly broad. And the Ninth Circuit agreed with her. So the government then petitioned to the Supreme Court, and the case is now in the court, and it will be argued next week. Now, Kristin, let me ask you this. What do you think might be the ramifications of this decision for people who are practicing immigration law?
I think the ramifications are potentially quite broad, and it's not only for individuals practicing immigration law. What happened again in this case was that the defendant actually she was an attorney, she was a lawyer, I should say a law graduate, let's be clear. She was not a licensed attorney at the time, so she had knowledge of what was going on, but she was not an attorney. As we look at how this can play out for immigration attorneys, as well as anybody who's providing immigration advice, the concern is, what do the terms encourage and induce mean? Induce is a more narrow term than encourage, and it's really the encourage prong that raises a level of concern here. Does that mean advising a client on what the implications may be of staying in the United States if they're here currently unauthorized? Does that mean advising a client on coming to the United States? Does that mean a minister who may be assisting a parishioner who's currently in the United States? There are some immigration benefits that an individual can only apply for if they are already in the United States. There are circumstances where an individual needs to be in the United States for a certain period of time in order to apply for these lawful immigration benefits. So it's not just a matter of somebody being here, as we term unlawfully. It's a matter of what can we do, or are we able to assist individuals and advise them appropriately on what the law is without actually encouraging them to stay or exposing ourselves to potential liability.
So it's very much a matter of what you can say to an immigrant who is here unlawfully. It applies to speech, in other words.
It does apply to speech, and I'm gonna mince words a little bit as it relates to unlawfully. An individual who stays in the United States beyond their authorized period of stay is not necessarily violating a law, so to speak. Can they be deported? Yes. But is there a crime associated with that in the criminal context? Not necessarily. We're talking about somebody who is just not authorized to be in the United States at the time.
Yeah, so being here without legal status is not a crime.
That's correct. It is
Yeah.
not a crime.
Yeah.
It does violate a law, but it is not a crime.
Yeah, it makes a person susceptible to immediate removal, but it's not a crime.
That is correct. They may be placed in removal proceedings. But again, even in removal proceedings, they may have relief from removal that an immigration practitioner, whether it's an attorney or otherwise, would need to advise them on.
Well, let's talk about the distinction, which I think you made, between encourage and induce. Now, you said that encourage is a broader term, and induce we might consider to be a subset of encourage. And it seems to me that there is a difference in meaning of those terms. Let's suppose a person is employing an illegal alien, and knowingly employing an illegal alien and paying them money. In your view, would that constitute inducing the illegal alien to stay here?
That's a very concerning question, and it's a question that was addressed in a prior case out of Massachusetts involving a defendant named Henderson. The concern there, or at least the government's argument, was that by employing an unauthorized immigrant in the United States for money, you are thereby furthering their economic situation and encouraging and enabling them to stay in the United States. And that was what the government had advanced in that case.
Well, one of the arguments the government has made is that the statute should not be declared invalid on its face. It might be unconstitutionally applied in certain cases. And they have argued in their brief that, as a backup argument, that the Supreme Court should not declare the law facially unconstitutional, and if anything, they should view the law as susceptible in some cases to being applied unconstitutionally. And would it be a viable distinction, do you think, to distinguish between simply words of encouragement, such as the grandmother who says to her grandson, "I wish you would stay here, I really want you to stay here," between that and a situation where a person not only uses speech to encourage, but also takes some action which is an inducing action, such as in the Henderson case, paying wages to an illegal? Would that be a viable distinction, you think, that could save the statute and limit it to only those cases of inducement where there's some collateral action and exclude it from cases that are only encouraging speech?
John, my concern with what you're proposing there is that I'm not clear exactly where that line is. And if I'm sitting here, I need to understand what the parameters are for when I'm violating a law and when I'm not. And the big concern that I see with the position that says, let's see how it's applied in each case, is that we're then relying upon the government and the government's kindness and benevolence in what they decide to prosecute. What was pointed out is that the government, when this matter was before the Ninth Circuit, was asked whether or not the situation of an attorney providing free legal advice to an undocumented immigrant would be the situation that you're talking about. The government's response is that that would be a hard case.
Well, that would be a hard case, true, but the Supreme Court deals with hard cases all the time. And the Supreme Court could do some surgery on this statute. And they could say that situation where a lawyer is giving free advice, it cannot be prosecuted. And the Supreme Court has done this in other cases. For example, in the Skilling case regarding the statute prohibiting honest services fraud, where honest services was considered to be a very vague term, the court did a little surgery and they said, the government, you can't prosecute honest services fraud unless it involves bribery or kickbacks. In other words, they cut it back. And could they do that here?
The concern with cutting back, though, is that we're looking at the effect on speech and whether or not there's going to be a chilling effect on constitutionally protected speech. And I would argue that there possibly can be. If I'm an immigration practitioner looking at this, do I need to be concerned about the advice I give to my clients? If I work at an organization that provides free legal services or immigration advice, do I need to be concerned about what I tell my customers? If I'm a minister, I'm a therapist, I'm an individual who happens to, have somebody cleaning my house. Do I need to be concerned about what I say on a daily basis to these individuals? Am I going to change my way of speech? Am I going to change what I say? There's a likelihood that that's the case.
Well, this is a vexing problem. There's no question about it. I think it is, well, I don't know what the Supreme Court might do with it, but I suspect there will be some of the justices would want to try to salvage this statute if possible and cut it back and limit it to more egregious cases, like the case before the court. Here was a case where it's pretty obvious that that the defendant defrauded her clients and illicitly was encouraging them to stay for her own profit and her own benefit. Now, would that be one way to cut back this statute and save part of it? In other words, a holding which said that encouraging words which are accompanied by actions or efforts to profit from them, would that be a viable distinction? Do you think that would be a clear enough guideline to practitioners in the field?
No, it would not. Part of the concern here is, again, many immigration practitioners are for-profit businesses. They're attorneys. They charge their clients. And it's not, I think the distinction to be made here is the government's argument is that even if the defendant was correct, even if she was correct on the state of the law at the time, the government could have still prosecuted her under this. So the what we're calling the encouragement clause has little to do with the actual fraud that was committed by the defendant, but more to do with her recommendation, encouragement, advice, so to speak, to individuals who were immigrants in this country without status to remain in the United States. And if that's what the concern is, which seems to be where the government is going with this, that would have applied regardless of whether or not those individuals were eligible to apply for labor certification or whether that provision had sunsetted as it had in this case.
Yeah. So if I understand what you're saying, you see a clear distinction between the fraudulent acts by the defendant on the one hand as distinct from whatever speech she may have made or whatever words she may have spoken to her clients.
No doubt. And as I think you pointed out at the beginning, what she did in this case was not appropriate from all the facts that we see. But that's a separate matter from whether or not she should be subject to a felony prosecution for this encouragement clause provision.
Well, do you think there's your view obviously is I think I'm fair in saying this, that your view is the statute is facially unconstitutional and it's just simply not workable. Is there any way to estimate potentially how many thousands and maybe hundreds of thousands of people might be violating this statute all the time?
I think that you just put that number there yourself. This could be potentially anyone. And the concern here, again, is not with the particular facts where this case has been applied, but with the government's argument as to where they think this case could be applied. And in that case, it could be the housewife who employs somebody who helps to clean her house. It could be the minister who's advising a parishioner. It could be the immigration practitioner, and it could be the pro bono services provider.
Well, I wonder why the government felt the need to take this case to the Supreme Court. I wonder if possibly it could be directed at curtailing sanctuary city efforts, for example. Let's suppose a local councilman on a local city council advocates declaring the jurisdiction a sanctuary city. Would that be encouraging illegals to remain in the United States?
Potentially, it could be. Although I will modify that a little bit in that if we look at the Henderson case, that was decided in 2012, well before the current administration and the issue of sanctuary cities, and the government was asserting a similar argument at that time with respect to the encouragement clause.
Well, Kristin, thank you very much for your views on this. I think we'll just have to wait and see how this turns out. It's being argued next Tuesday, and the argument should be available for audio listening a few days after that, and perhaps when it's argued, we can come back and revisit this and make our prediction as to which way it's going to go.
I like that.
So-
Thank you.